Okay, so as Jane just said, I'm going to focus on the considerations around the return to work. And I'm specifically thinking about what you as employers and licensed sponsors need to think about. And obviously, a lot of this is going to be familiar to you. I'm talking about people who, because of the fact that you hold sponsorship licenses, have obligations concerning non-UK nationals either returning to work or starting at the UK office, whether that be in the office itself or working from home. Looking first at the monitoring and reporting requirements you have, I mean, I guess it's really worth saying it's important to emphasise how seriously these are taken by the Home Office. UK Visas and Immigration, the immigration authorities are not taking these any less seriously because we haven't necessarily been in the office for the last 12 months. They will look very carefully at whether you are continuing to comply with your duties as employers. What are these duties? Just to remind you, they'll be familiar to most of you. They're contained in Appendix D of the guidance for licensed sponsors, and basically you need to, as you know, use the sponsorship management system, the online portal, to manage your key personnel, to assign or issue certificates of sponsorship, and to report activities. So remember that on the reopening or the return to the office, however that's taking place, there are a number of things you'll need to report, and there are time limits. I mean, within 20 days, you need to make sure that you do issue a report using the sponsorship management system. If, for example, there have been changes to your business, for example, if you've been involved in a merger or acquisition, if you've changed your trade, if any of your sponsored workers have been absent for more than 10 working days and that absence is unauthorized, you've got 20 working days to make a report to confirm that. A number of things you need to report within 10 working days. Those include things like a migrant worker not turning up for their first day at work, if anyone has switched their status during lockdown into a non-sponsored status, for example, they've moved from being a skilled worker under tier 2 to being on a spouse visa, you need to report that. If they've been promoted or they've received a significant salary increase or some other major aspect of their work or position has changed, you need to make a report on that as well. So that's just some of the requirements you need to make sure you watch out for and issue the reports within, and those that I've just cited, within 10 working days. What about records? So obviously there are obvious things that you need to make sure you retain, again listed in Appendix D. Those include things like the passport copy with the visa stamps, either the skilled worker or the tier 2 or 5 visa stamps. You must have those on file. You need to keep a copy of the migrant's biometric residence permit. Also, very importantly and easy to forget, their current and their previous contact details, and as well as a full record of all their absences from work. I mean, I guess it's worth saying, never underestimate the willingness of the Home Office to conduct an unannounced compliance visit. And if you do receive a warning of a compliance visit that's going to check all this stuff, consider yourselves lucky. It's really important, can't emphasize this enough, that employers maintain meticulous records relating to sponsored workers, because you could very swiftly need to produce those records. So right from the start of your sponsor license, make sure that your records are all carefully kept, they're indexed, they're filed, and you could produce them when asked. I mean, the penalties for non-compliance of your reporting and monitoring requirements are potentially serious. I mean, you could mean your license is downgraded from an A rating to a B rating. You could be subjected to an action plan. And the worst case scenario for non-adherence is obviously that your license is revoked or suspended. And that could mean that the leave of all the permission to stay in the UK of all of your sponsored workers could be curtailed, which means that they could have to stop work and leave the country. So, you know, potentially catastrophic. Very important to take your sponsor duties seriously. Worth mentioning just very quickly that the Home Office have included an additional piece of guidance around advertising and the fact that advertising is now no longer required. Even though it's no longer required if you're taking on a skilled worker or the equivalent of tier 2, it's very important that you do keep some evidence of how you came to recruit that person. So you should keep a record of the number of people who applied for the job. You should keep a record of the number of people shortlisted for interview, and at least one item of evidence or information that shows the process that you undertook to select that person. You don't need to keep, application forms, CVs, or personal data relating to those who didn't you didn't choose, but it's very important that you're able to show, if asked, that you've selected this person because you need to fill a genuine vacancy, and you will be asked about that even under the new system. Moving swiftly on to right to work checks. Again, this is something you're all going to be familiar with. Your obligations are, as licensed sponsors or as employers of non-UK nationals, to ensure that checks are conducted on all employees, UK and non-UK, because you have to conduct them in a non-discriminatory way, and you need, in order to do that, you need to check people's prescribed documents to evidence their right to work in the UK, and those documents are listed again in the guidance. At the moment, people aren't going into the office. It's obviously important to ask people to bring in and show you their original documentation. So there is you're able to carry out a compliant right to work check by asking people to show you their documents over a video call. You can ask them to submit a scanned copy or photo of their original documents by email first, then you arrange a video call with them and ask them to hold up their original documents to the camera, and then you have to record that in writing and note it on the individual's personnel file, confirming that a right to work check has been undertaken and on which date. But I'm often asked about people who, employers who, for example, want to offer a post job to somebody, a non-UK national who may have made a visa application of some kind and is waiting to hear from the Home Office. But if you as an employer are reasonably satisfied that that person has an outstanding application with the Home Office, and it was made before their previous leave expired, you can ask for evidence of that. Or, for example, if they may have an outstanding appeal against Home Office decision that allows them to stay in the UK under the same terms, what we suggest you do is go onto the employer checking service and get a so-called positive verification notice. That will confirm their right to work, and that's fine to produce that as an online check, showing that you have met your requirements. What about EU nationals, very briefly? Previously, obviously, there was no requirement for you to undertake a right to work check because EU nationals enjoyed freedom of movement. That's now ended, obviously. EU nationals, since the UK left the EU, are subject to immigration control. And I think it's worth saying that the Home Office made an amendment to the guidance only on the 17th of March to provide guidance for employers in relation to right to work checks for people that they take on since we've left the EU, and what you need to do during the so-called grace period leading up to the end of the time limit for making applications under the EU settlement scheme. What the amended guidance says is there's no requirement for you as employers to undertake retrospective checks on EU nationals, but you can do so for people that you take on during the so-called grace period between January and June 2021. You can make those retrospective checks so long as you do so in a non-discriminatory manner. So you can just ask them to show their passport or national ID card, and that will enable you to obtain a statutory excuse against civil penalty that could be imposed on you if you've failed to undertake proper right to work checks. Okay, just a quick word now about compliance audit. Now, I guess I'm asked this a lot actually, does a return to work make a visit from the Home Office more likely? Well, yeah, possibly. There has been an increase in the number of compliance visits that the Home Office are undertaking. because a lot more people, a lot more companies have applied for sponsorship license, both for the first time and applied to renew these. So there has been an increase in audit activity, and we need to think about making, what you need to find to provide to the Home Office if you are indeed asked. What they're looking for, 5 key areas of compliance. They're looking for you monitoring and maintaining your checks on foreign nationals. What efforts are you making in terms of record keeping? How are you tracking and monitoring your foreign nationals? And how are you complying with general sponsor duties? Are you audit ready? That's what we need to think about now. Make sure that you've kept your record keeping up to date, that you have all the documentation to hand, that it's nicely filed and indexed. And for example, if you've got non-UK nationals placed at third-party client sites, make sure that you've got those client agreements and evidence of how you came to get that approved. The certificate of sponsorship applications, I always recommend making sure that you retain all the details you provided to the Home Office at the time of the initial application. What can be the results of compliance audits? Well, I mean, there are a number of outcomes. One of the most favourable is that you maintain your A rating. That means that, no further action is going to be taken. But if you have been shown to be in breach at any time, you could be downgraded to a B rating, and that's really serious, because it could be that you'll be subjected to an action plan, or even worse still, if the Home Office have decided that you as an employer have breached, have incurred serious breaches, you could find that your sponsorship license is suspended or revoked, and that's really bad, because it could mean that you'd have to basically stop employing all of your non-UK nationals who are here on certificates of sponsorship, because their leave would be curtailed. So it is potentially catastrophic. Very briefly, working from home abroad. Obviously, what do you need to think about? You don't need to think about this unless that you're talking about somebody who's working from a country that is not their country of origin. But what about those who are coming to the UK, maybe would be working for you part-time? Remember that you need to make sure that you have given them, they have permission to work for you, even if it's only part-time, say as a student or as an intern, and you've documented that. I mean, the pandemic's created an accidental group of remote workers. So even though a worker might not be in the office or even working in the UK, employers, licensed employers, remain under an obligation to track and monitor all of their sponsored employees' activities and report those events that I mentioned earlier to the Home Office. For example, a change in working hours or job duties. There is currently a concession in place that exempts employers from reporting changes in their job location, because obviously that's happening more and more frequently. What about those working from home abroad? I mean, make sure that they have the visa and the permission to work wherever they're working from if they're not a national of that particular country. I mean, working in breach of local immigration laws can have serious consequences for individuals. So yeah, I mean, just make sure that you understand what your obligations are, and that you might want to ensure that that's input into their contracts of employment. Just a very brief word about coronavirus concessions now. I mean, main thing to say is the government have made it very clear that nobody is to have a negative outcome through the immigration system due to a circumstance that was beyond their control. So if one of your employees' leave is expired or is expiring and they're outside of the UK unable to return, the Home Office are being reasonable about applying their discretion and applying for a new visa. There is a grant of exceptional assurance that you can apply for. It can be made online, but we can't talk generally about whether that's going to be approved. It will be all dependent on timing and on their individual circumstance. I mean, I guess the only thing really to say here is do seek advice before you put any changes into effect to make sure that you and the employee are compliant with immigration law, because individual circumstances will be taken into account and treated differently by the Home Office. So that concludes my whistle-stop tour. Very happy to answer any questions anyone has.